Legal brief. Writing agent. TBQI quality system. What happens when AI hallucinates a court case in a legal brief? I'll tell you what happens. An attorney files the brief. The opposing counsel can't find the cited case. The judge orders an explanation. The attorney says their AI assistant generated it. The court issues sanctions. The Bar Association opens an investigation. A career built over 20 years gets a permanent stain because of one fake citation. This isn't hypothetical. Variants of this have already happened, and it's the reason we spent months building a legal brief writing agent that treats hallucination prevention not as a feature, but as the foundation of every single thing it does. Today, I'm taking you inside the Scrivener, our legal brief writing agent, and the TBQI quality system that keeps it honest. Let's start with the big picture. The Scrivener operates on a 12-stage pipeline. Every legal brief, whether it's a complaint, an answer, a motion to dismiss, or an appellate brief, goes through all 12 stages. No exceptions, no shortcuts. Why 12? Because we learned the hard way that skipping stages produces garbage. Early versions had 8 stages, and attorneys kept finding issues that slipped through. So we added stages until the error rate dropped to where we wanted it. Let me walk you through them quickly. Stage 1 is case file ingestion. The system reads every document in the case file: pleadings, evidence, correspondence, court orders. It doesn't summarize them yet. It indexes them. Stage 2 is fact extraction. The system pulls out every factual assertion from the case file and tags each one with its source document. Every fact gets a citation. If it can't be cited, it doesn't exist. Stage 3 is legal issue identification. Based on the facts, what are the legal questions this brief needs to address? The system generates a preliminary issue list. Stage 4 is authority research. For each legal issue, the system searches for relevant statutes, regulations, and case law. And here's the critical part. It only uses verified legal databases. No general internet searches. No Wikipedia. No AI-generated summaries of cases. Stage 5 is argument construction. This is where the actual legal reasoning takes shape. For each issue, the system builds an argument following the standard legal analysis framework. Rule, application, conclusion. Stage 6 is counter-argument anticipation. The system asks itself, what would opposing counsel say in response to each argument? Then it drafts preemptive rebuttals. Stage 7 is structure assembly. The arguments get organized into a logical brief structure: introduction, statement of facts, argument sections, conclusion. Stage 8 is citation verification. Every single case citation gets checked against the legal database. Does the case exist? Is the citation format correct? Is the case still good law, or has it been overruled? That stage alone catches about 12% of initial citations that are either incorrect or outdated. 12%. That's roughly 1 in 8. Stage 9 is internal consistency check. The system verifies that the facts stated in the argument section match the facts in the statement of facts section. You'd be surprised how often these drift apart in human-written briefs too. Stage 10 is tone and register calibration. Legal writing has a specific register: formal but not archaic, precise but not pedantic. The system adjusts language to match jurisdictional expectations. Stage 11 is format compliance. Court rules specify everything from margin widths to font sizes to page limits. The system checks all of these against the applicable rules. Stage 12 is final quality assessment using the TBQI scoring system. We'll get to that in detail. Now, running through 12 stages means nothing if the underlying rules are weak. So let me tell you about the 7 iron rules. Iron rule number 1. 0 fabricated citations. This is non-negotiable. If the system cannot find a real case that supports a proposition, it flags the proposition as unsupported rather than inventing a citation. I'd rather have a brief that honestly says, "We couldn't find direct authority on this point," than one that cites a case that doesn't exist. Iron rule number 2. Source-locked facts. Every factual statement in the brief must trace back to a specific document in the case file. The system maintains a fact-to-source mapping that an attorney can audit in under 5 minutes. Iron rule number 3. No argument without adversarial testing. Before any argument makes it into the final brief, it has to survive the counter-argument stage. If the system can demolish its own argument, that argument gets flagged for human review. Iron rule number 4. Jurisdiction-specific authority. A case from a different jurisdiction can be persuasive, but it's not binding. The system clearly labels every citation as either binding or persuasive authority, and prioritizes binding authority. Iron rule number 5. Proportional citation density. More complex or contested points need more supporting authority. A straightforward procedural point might need 1 citation. A novel constitutional argument might need 6. The system calibrates automatically. Iron rule number 6. Plain language requirement. Legal jargon is sometimes necessary, but it should never be used to obscure weak reasoning. The system flags passages where complex language might be masking a thin argument. Iron rule number 7. The 2-version mandate. And this one is important enough to deserve its own section. Here's what the 2-version mandate means. For every brief, the Scrivener produces 2 complete versions. Not a draft and a final. 2 distinct versions with different strategic approaches. Why? Because legal writing involves judgment calls. Should the brief lead with the strongest argument, or should it build momentum by starting with the easiest wins? Should it address the opponent's best argument head-on, or minimize it? Should the tone be aggressive or measured? Reasonable attorneys disagree on these questions all the time. So instead of making one choice and hoping it's right, the system produces 2 versions, each taking a different strategic approach. The supervising attorney picks the one that better fits their strategy, or combines elements from both. In our benchmarking, attorneys chose version B over version A about 42% of the time. That means neither version is consistently better, which validates the entire approach. If version A were always chosen, version B would be a waste. The fact that it's close to 50-50 means both versions are genuinely offering different strategic value. Now let's talk about TBQI. It stands for Technical, Behavioral, Quality, and Impact. 4 dimensions that together produce a composite score for every brief the system generates. The technical score measures citation accuracy, legal reasoning validity, and procedural compliance. Is every citation real? Is every legal argument logically sound? Does the brief comply with all court rules? The behavioral score measures how well the brief anticipates and addresses opposing arguments, judicial concerns, and potential weaknesses. Does it ignore the elephant in the room, or does it confront it? The quality score measures writing, clarity, concision, persuasiveness, and readability. Legal writing can be technically correct, but utterly unpersuasive. This dimension catches that. The impact score is the most subjective and the most important. It asks, if you were the judge reading this brief, how likely would you be to rule in favor of the party filing it? We calibrate this using a panel evaluation method. The system simulates 3 different judicial perspectives and averages their assessment. Each dimension is scored on a 100-point scale, and the composite TBQI score is a weighted average. Technical at 30%, behavioral at 25%, quality at 25%, and impact at 20%. We benchmarked this system against 35 real briefs filed by experienced attorneys. The briefs were anonymized, no party names, no case numbers. We ran them through the TBQI scorer alongside AI-generated briefs on the same legal issues. The results were interesting. On the technical dimension, the AI briefs scored an average of 89 compared to 82 for the human briefs. That makes sense. The AI is meticulous about citations and formatting. Machines don't make typos. On the behavioral dimension, humans scored 78 to the AI's 74. Experienced attorneys have better intuition about what a specific judge cares about. On quality, it was nearly tied. 76 for humans, 75 for AI. On impact, humans edged ahead. 71 to 67. The composite scores were close. Human average, 77.2. AI average, 76.4. Less than a point apart. But here's what matters more than the scores. The AI briefs took an average of 47 minutes to generate. The human briefs took an average of 14 hours to write. Even accounting for the attorney review time needed for the AI output, about 2 hours on average. The time savings are enormous. Now, let me tell you about the fusion approach, because this is where it gets really interesting. We had 2 attorneys on our team with very different styles. One was methodical, detail-oriented, with dense citation work. The other was a storyteller. Her briefs read like narratives that happened to be legally rigorous. Both were excellent. But they were excellent in different ways. So we trained 2 separate style profiles and built a fusion mode that combines their strengths, the citation density of the first attorney with the narrative flow of the second. The fusion briefs consistently scored 3 to 5 TBQI points higher than either individual style profile. That's the real power of this system. It doesn't replace attorneys. It takes the best of what multiple attorneys do and combines it in ways that no single person could. Let me close with what's coming next. We're working on judge-specific calibration, analyzing a judge's past rulings and written opinions to tailor the brief's style and emphasis. We're also building a revision agent that takes feedback from court hearings and automatically suggests amendments for subsequent filings. The goal has never been to remove attorneys from the process. The goal is to make the first draft so good that the attorney's time is spent on strategy and judgment, not on formatting, citation checking, and fighting with word processors. If you're working in legal tech, or you're an attorney curious about how AI can fit into your practice, hit subscribe. Next video, we're covering the demand letter agent and the very fine line between persuasion and coercion. See you there. NDE